Welcome back to the Jurist Prudence channel, the home for summarized South African case laws. Administrative law is mainly about determining whether or not actions amounts to an administrative action or not. Today we are looking at a case between FEDSURE Life Assurance Limited and others v. Greater Johannesburg Transitional Metropolitan Council and others 1999. In this case, the appellants, 10 corporate ratepayers in the Eastern Metropolitan Substructure, which will be referred to as the EMS, objected to a substantial increase in their property rates. They challenged the lawfulness of certain resolutions adopted by the Greater Johannesburg Transitional Metropolitan Council, in this case summary referred to as TMC, in relation to their 1996-97 budgets which had given rise to this increase. Initially, the appellants applied to the Witwatersrand High Court to have their rates, levies and subsidies set aside. Unfortunately, the judge found the resolutions to be lawful and dismissed the application. The appellants appealed against this decision. However, the appeal court affirmed that it was not able to entertain the appeal, since the attacks raised constitutional issues. Accordingly, it referred two questions to the Constitutional Court. 1. Whether the resolutions were consistent with the interim constitution, and 2. If they were, whether the Supreme Court of Appeal had any residual power to decide the various challenges. The appellants challenged the resolutions on a series of grounds. At the hearing in the Supreme Court of Appeal, the parties were agreed that the resolutions relating to the rates, levies and subsidies were administrative actions as contemplated in Section 24 of the interim constitution. However, the respondents argued that they were legislative, and not administrative actions. The court accepted this argument. Nonetheless, the justices were agreed that all legislation must comply with the Constitution. An important principle of our Constitution is the rule of law, which means at very least that any exercise of power by an organ of state must fall within the limits of the power conferred on that body. Courts, including the Constitutional Court, may thus review and set aside legislative action which does not comply with the principle of legality. The appellants argued that the resolution increasing property rates within the EMS was unlawful, since these additional funds were necessary, not for the EMS's own purposes, but rather for the payment of a levy to the TMC. This challenge was unanimously rejected by the court. The justices noted that the process of drawing up a budget involves making considered estimates as to items of expenditure, which are likely to be incurred during the relevant financial year. Secondly, the appellants contended that the resolution of the TMC imposing a levy on the EMS and NMS was unlawful, because the levy was not equitable and was not based on the gross or rates income of the substructures. The court was evenly divided on this question. In a joint judgment of President Chaskalson and Justices Goldstone and O'Regan, concurred in by Justices Ackerman and Madala, it was held that the levy was not sufficiently closely linked to either gross or rates income for it to have been based on such income. Indeed, the evidence indicated that the levy was based on the surpluses generated in the EMS and NMS. Hence they concluded that the TMC levy was unlawful. In a separate judgment concurred in by Deputy President and Justices, found that it was not necessary that the levy be based exclusively on gross income. It was sufficient that the levy be related to gross income. Justice Kriegler held that the levy was directly related to the EMS's gross income and thus that this ground should fail. Thirdly, the appellants contended that the levy was unlawful, on the basis that it was not necessary for the TMC to exercise its powers and perform its functions, and that it was not based on a uniform structure for the TMC's area of jurisdiction. In Justice Kriegler's view, the interdependence of the TMC and its substructures, and the TMC's constitutional duty to provide for the well-being of all persons within its area of jurisdiction, entailed that it had the power to impose a levy on one substructure for the purpose, not only of balancing its own budget, but also of making a grant to subsidize another substructure's deficit. Furthermore, given the cooperation between the TMC and its substructures in financing each body's expenditure, and in particular the decisions to standardize property rates and service tariffs across the Greater Johannesburg region, the levy was based on a uniform structure for the TMC's area of jurisdiction. Hence, in Justice Kriegler's view, the TMC levy was lawful. Finally, the appellants claimed that there were certain procedural irregularities in the manner in which the TMC and EMS budgets were prepared and approved. The court found that the required procedures had in fact been followed, and unanimously dismissed this ground. In relation to the second question referred by the Supreme Court of Appeal, the justices were unanimously agreed that the SCA did not have power under the interim constitution to hear constitutional matters. The court concluded that the resolutions of the TMC and EMS did not amount to administrative actions for purposes of Section 24 of the interim constitution, but had nonetheless to comply with the constitutional principle of legality, that the property rates imposed by the EMS on its ratepayers were lawful, and that the procedural requirements relating to the presentation and approval of the TMC and EMS budgets had been fulfilled. Accordingly, the entire appeal was dismissed with cost. Thank you for watching. If you found this video interesting, please go ahead, like, comment, subscribe and hit the bell button for notifications. Take care. Forever your law buddy, until the jury do us apart.